Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing parole, statutory release, and dangerous offenders. The issue has come to the forefront of public attention after the high-profile case of Myles Sanderson. Mr. Sanderson went on a stabbing rampage in rural Saskatchewan that left 11 people dead and around 19 people injured. 7 months before that mass killing, a parole official had ruled that Sanderson did not pose a danger to society despite his 59 criminal convictions. He was released into the community on statutory release. The Parole Board of Canada and Correctional Services Canada have launched an investigation into the decisions that led to his release. Here today to discuss the topic are two experts. Ari Goldkind is a criminal defense lawyer, and Howard Sapers is a former correctional investigator of Canada. Thank you both so much for joining me today. Ari, I just want to start at the high level. We're going to be talking about Mr. Sanderson as an example, his case as an example, but we're going to be talking about this as a system level as well. But in the Sanderson case, is there anything you want to add to what happened from my description at the beginning there?
No, I think your description sort of sets it out, but a lot of Canadians are being told this is a unicorn. This is an outlier. There's a cliche in my business that bad facts make bad law, and that people shouldn't worry too much about this, that everything is hunky-dory and there's nothing to see here. The Sanderson situation is a disgrace on multiple levels. The only time you can say it's not a disgrace is if you don't care that 30 people were butchered, 11 people killed, 19 people stabbed. By the way, in his own community, when it was well known to everybody with half an iota of sense that he was a ticking time bomb. So while this is not a fully parole board or correctional services problem, we'll get into what statutory release means and what options they had available to him. There's a real systemic failing here with, in my view, the Crown's office to not seek a dangerous offender designation. We'll talk about throughout the show. But this is not something that Canadians should listen to sort of experts when they say, oh, everything is working just great, don't worry about this. Not if you're a family member or a loved one of those 30 people that were left to be sitting ducks at the hands of a man who was given his 60th, I emphasize, 60th chance to not be violent again.
So, Howard, I want to let you respond to any of that, although I know you'd prefer to talk about it at a system level as opposed to the Sanderson case specifically, because there's still a lot we don't know about that case. But one of the things, Howard, I want to emphasize is that Mr. Sanderson was given something called statutory release. So can you explain what that is and how that fits into what happened in this case?
Certainly, Christine, and I'm happy that Mr. Goldkind started his response with mentioning the devastation of this particular incident, tragedy for the families, for that community, for everybody involved, and my heart goes out to those who are grieving. It is a fact that when things go wrong in the administration of justice, the administration of somebody's sentence, they can go horribly wrong, and this is an example of that. And it doesn't really matter whether they're rare or not. If they happen once, it's something we've got to address and take very seriously. And your question about statutory release is also a good place to start, because there's a lot of misunderstanding, I think, in the public about how people get out of prison. So obviously, they get out of prison at the warrant expiry. But we know through years and years and years of evidence around the world that that's the worst way for most people to get out of prison, because just going out cold turkey can be dangerous in itself. So we have a system of conditional release, and the strategy is to allow people to be supervised under conditions while they are released in the community until their warrant expires or until the end of their sentence. So statutory release is actually the least desirable form of that kind of conditional release. The first is day parole. And day parole is for people to sort of test their wings going out into the community. Typically, they live in a halfway house. They have conditions about residency and sobriety and other things. And we have a pretty good track record with day parole. The vast majority of day parole periods are successfully completed without a new offense or any breach or anything else. The next level would be full parole, where perhaps you no longer have to go to a halfway house, but you're allowed to live in your own home, maintain your job, live with your family, but you still have conditions. You're still reporting to a parole officer with conditions around things like geographic restrictions and the kinds of relationships you must report and those kinds of issues. Again, we have a pretty good track record. And these kind of releases have been going up for the last decade. Since about 2010, they've been increasing in their frequency, but with no decrease in the reliability.
Howard,
the last
Howard,
was statutory
we've got to go to break, but we'll be right back.